Senate versus House. That's item number 374786.
Lasher, Abdicum Magassett, along with my colleague Steve Liedl at council table on behalf of the House of Representatives for Michigan's 103rd legislature and its clerk. There have been countless disputes and infighting between the two bodies within the Michigan legislature. So this court should leave it to the legislature to resolve its own disputes. Michigan's legislatures are not continuing bodies. They're not bound by prior legislatures. Each legislature lasts for 2 one-year sessions. And at the end of those 2 years, any unfinished business of that legislature dies with that legislature. Anything that's still left on that legislature's desk is wiped clean, and it does not carry over for the new legislature to finish. And that's what this entire case is really about. After that legislature no longer exists, neither do the bills.
But why couldn't the rule just be present it right away?
Because that's not what the Constitution says. The Constitution expressly leaves it to the legislature to do so. I think you're really infringing on legislative authority by reading words into the Constitution and imposing an immediacy requirement. And so, again, under Article 4, Section 1, all legislative power is left to the Senate and the House. There have been many instances in the past where bills that have been enrolled, the legislature decides to, at some point in time, vacate those enrolled bills. That's something that's within the legislative power.
Just a moment ago said you can't read into language that's not in the text of the Constitution, but a moment later you say that these bills that are not presented lapse. What text in the Constitution are you relying on?
I think Article 4, Section 13, which under that provision, it says any business or bills that are pending at the end of an odd-numbered year carry over to that same legislature's second session.
So you're referring to that as being business, not bills?
Yes, yeah. I think the act of presentment...
You're conceding that it's not a bill because it's been passed by both chambers.
The bill has been passed by both chambers, that's correct. And there was still an extra step that the legislature had to take before a bill could become law. And that extra step was presentment. That legislature failed to take that step.
You said that the legislature has the ability to vacate enrolled bills. Where's that power come from?
I think Article 4, Section 1, there's been numerous instances in the past where that's occurred and not been challenged. So, but
the Constitution also says you have to present the bills to the governor. And that also includes the governor having some interest in how this process works out, doesn't it?
I think if anybody has an interest, it's probably the governor. And I think really notably, the governor has not come to this case to...
Well, but that doesn't matter. I mean, the Constitution says it has to get submitted to the governor so the governor can sign it or veto it, right? I mean, that's how the process works.
It says every bill passed by the legislature shall be presented to the governor before it becomes law.
And doesn't the governor have interest in seeing bills passed by both houses to be submitted to her so that she can consider it and whether it should become law?
I think if she does, then I think the failure of that to happen...
She does. I mean, not if. Of course she does. But you keep saying this is just a internal legislative issue. It's not. Because it impacts whether the governor can sign bills that were passed by both houses of the legislature. What happens if let's say in January of the start of the second year of the legislature, okay?
Mm-hmm.
So you still got a whole year to deal with your business before that legislature ends. And some bills are passed and one party controlling one of the two houses says, we don't like this. So let's just hold on to it for the entire year. And then it lapses because a new legislature is sworn in the following January. Now what's the remedy for that? Is it the voters kick the bums out, or what is it?
I think that's part of the remedy. I don't think this court has ever imposed a deadline when there is none. And so
I'm not talking about a deadline. I'm asking, though, the problem is obvious, right? It's a frustration of the legislative process that's set forth in the Constitution. And your answer is, well, they can do that. And then you frustrate or virtually eliminate the whole legislative process that we have in our Constitution.
Yeah,
so there's got to be some kind of remedy for that. And if it's not a legal one through the courts, what is it? What's the political response?
So Article 4, Section 33. So the first sentence, every bill passed by the legislature shall be presented to the governor before it becomes law, and the governor shall have 14 days measured in hours and minutes from the time of presentation on which to consider it. So there, it doesn't say anything about whether the legislature is still in session, that kind of thing. The paragraph then goes on, the section then goes on to talk about, when the governor's considering it, whether the session has been adjourned yet. In various ways, I think it's mentioned 2 or 3 times in the rest of the paragraph. And the final sentence of this section says, if any bill is not returned by the governor within such 14-day period, the legislature continuing in session, comma, it shall become law as if he or she had signed it. And so it seems like whoever drafted this section knew all about the fact that legislatures adjourn after a certain amount of time, and put that in a lot of parts of this section, but did not stick it in that first sentence, which says that that every bill that's passed shall be presented. What do you make of that omission from that first sentence?
So I think the rest of Section 33 supports the fact that a bill has to be presented by the same.
I think there are different ways to read it, right? The fact that there's no mention in that first sentence about the end of the adjournment or the end of the session, and it is mentioned elsewhere, could speak in the other direction as well.
If we disagree with your position,
Yep.
would you agree with the fact that mandamus is the proper remedy?
I think if you disagree with everything I've said, I think they have to meet the standards for writ of mandamus to be entitled to relief.